The hearing changes direction the moment the courtroom has to manage repeated disruptions instead of focusing only on evidence. That matters because courtroom behavior becomes part of the credibility picture, even when it is not the legal issue being decided.
Okay, and for the record, the telephone number that I dialed earlier, dialed into the court hearing. I allowed it in. It's the same number that I called Ms. Clute on based on the loud outburst that we received. I'm pretty sure it's Ms. Clute. I have muted her so she can at least hear what's going on, but I am not going to allow her to speak because of her frankly outrageous bursting forth with vulgarities and profanities. I'm not going to allow her to disrupt this court hearing in that manner. And for the record, it looks like she just logged off. Go ahead.
Thank you. So was I understanding you correctly that Amanda Clute said just to put Kingsley into care?
Yes.
Okay. I want to talk more about Miss Clute's mental health. Did you ever learn any diagnoses that she has?
I did.
Can you tell me what those are?
Just 1 second. I know she was diagnosed with post-traumatic stress disorder, and I know that she has a history of depression, anxiety, and being bipolar.
Is it your understanding that Miss Clute is prescribed medicine for those conditions?
Yes, but she's not compliant with it.
Okay. Is it your understanding that Miss Clute should be in some sort of counseling for those conditions?
Yes, ma'am.
And is she currently doing so?
Not as of the date I wrote the petition, no.
Then use the right lane to take the US 23 northbound.
In terms of her health, while she was pregnant, was she participating in any sort of prenatal care?
No, ma'am.
Was there ever a time where Miss Clute left the hospital without medical care for Kingsley?
Yes, ma'am. She was scheduled to have 2 scheduled C-sections, and after 1 hour of being at the hospital, she left both times.
What else caused you concern about Miss Clute?
Basically her being irrational. You know, I tried to talk to her. She just from jump would not talk to me. And I tried to explain to her. She told me that she had a terrible history in Jackson County, and that's why she gave birth in Wayne County, which I understood. I tried to explain to her that it didn't matter that she had issues in Jackson County.
Excuse me, that's a lie. I would like to.
Obviously, you see Ms. Clute found her way back in. I'm going to keep my finger ready on the mute button so that when she does unmute, it doesn't stay that way for long.
You can go ahead, Miss Brown.
Okay.
I'm allowed to.
Go ahead.
Okay. So that's why she had the baby in Wayne County. And I tried to explain to her that it's still the state of Michigan and I would have to review her previous history in Jackson County. That's when she told me that the previous CPS worker tried to kill her.
That is a lie.
All right, just a second. I'm Ms. Clute. If there is another outburst, I am going to remove you from the courtroom and I will not permit you to come back in. You are able to observe the proceeding. It's being broadcast live on my YouTube channel. But if there's another outburst, I'm going to remove you and I will not allow you back into the courtroom. Go ahead.
Thank you. what kinds of services has Ms. Clute been offered in this case, if any?
None.
Okay. What sort of reasonable efforts have been made either with Ms. Clute on this case or previous cases?
Well, in all the cases, there was an FTM held. We reached out to relatives. We reviewed all the previous CPS case files and the legal files and the probate court record files. We tried to place with relatives. She's been offered substance abuse services. She's been offered parenting classes. This is previous to this case, and none were completed.
Okay. So Kingsley is currently in foster care, is that correct?
Yes.
Okay. And to your knowledge, and this may be more of a question for the foster care worker, do you know if Ms. Clute has had any contact with Kingsley?
I do not know.
Okay. Based on all of that information you gathered about Ms. Clute, you filed a petition asking for the court to both take jurisdiction of the child as well as terminate Ms. Clute's parental rights. Is that correct?
Yes.
In just talking about the portion where you asked the court to take jurisdiction, are there any other concerns regarding Ms. Clute that we have not discussed?
No, the most important things were the mental health and the substance abuse.
Okay. And again, you said that Kingsley tested positive for substances upon birth, correct?
Yes. Cocaine and marijuana.
Okay, thank you.
You're welcome.
In terms of the portion of your petition that you asked the court to terminate the parental rights of Ms. Clute, I want to focus on that for the remainder of your testimony. Is that okay?
Yes.
Okay. So can you tell me the general basis for which you ask for termination?
The general basis is Ms. Clute has untreated mental health issues, and she also has substance abuse issues. Ms. Clute has had 3 children go through the system, and
the judge repeatedly protects the process rather than reacting emotionally, signaling that order comes before anyone's frustration. At the same time, the questioning moves away from isolated incidents and starts building a broader pattern.
She's been offered services in the past, but she's never completed them. And every time, when my review of the records in Jackson County is when it came time to terminate her rights, she relinquished her rights.
Okay. So just to be thorough, I'm going to take you through the statutory bases that are in your petition, and we're just going to talk about those one by one. So then looking at the first one, you identify that the child's parent is unidentifiable, has deserted the child for 28 or more days, and has not sought custody of the child during that period. Can you tell me why you use that as a statutory basis for termination?
I did that because we cannot locate the father.
Okay, so that basis was more based on the putative father, correct?
Yes.
Is there any part of that basis that you feel applies to Ms. Clute?
Well, I know that when the baby was in the hospital, she never visited the baby. And I know that she hasn't made any attempts to contact me. I don't know if she's attempted to reach out to foster care.
Thank you. Looking then at the second statutory basis, you indicated subsection G, the parent, although in the court's discretion financially able to do so, fails to provide proper care and custody for the child, and there is no reasonable expectation that that parent will be able to provide proper care and custody. Was that more based on the father or Ms. Clute?
It was both. It was based on both. Ms. Clute has an income, but Ms. Clute did not provide anything for her baby. For example, she didn't have a bassinet, she didn't have a crib, she had nothing, no provisions for her baby.
Okay.
Can I point out a handful of lies that this woman has spewed from her mouth?
All right. Ms. Clute, that's your last warning. You're gone.
Call the cops. Call the cops.
Ms. Brown, you stated that she did not have things like a bassinet or any other supplies necessary to care for an infant child, correct?
Correct.
Tell me how you came to learn that she was without some of those supplies.
I asked her.
Okay, so you didn't like go to where she said she was residing or anything like that and see that she had an absence of that?
No, I asked her, did she have anything for her baby? And she said she didn't have anything for her baby. And I asked her why not. And she really couldn't give me an answer. And at that time, she didn't have anything to say to me. So she was very rude, very argumentative. And I tried, but it just didn't work out.
And you had said that you felt that she was financially able to provide those supplies?
Yes, she has an income.
Okay. Can you tell me more about that? Where does she currently work?
She doesn't. She receives Social Security.
Okay, thank you. Looking then at subsection I that you listed, and we've already talked about this a little bit. You mentioned that she had prior terminations, correct? Or prior relinquishes of her parental rights.
Yes, ma'am.
Okay, and so that would cover why you use that statutory basis. Looking then at subsection J, you use the statutory basis, there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child will be harmed if he or she is returned to the home of the parent.
Yes.
Can you tell me why you feel that Kingsley would be harmed if he was, if she was returned to the care of Ms. Clute?
Ms. Clute has unresolved mental health issues. Ms. Clute was not even, with the exception of one conversation, Ms. Clute was not even able to hold an adult conversation with me. And I understand that she's mad, she's upset, she doesn't like the system. I understand all of that. But she would not even talk to me. She cursed me. She hung up on me. She was disrespectful. She was rude. So I'm very concerned about her mental health issues, extremely concerned. If you can't have a general conversation with another adult, what would happen if you needed to take Kingsley to the hospital and they said something you didn't like? So I'm very concerned about the mental health, extremely concerned.
Okay, thank you.
You're welcome.
Ms. Brown, are you able to speak to how Kingsley is doing in foster care?
No, I am not.
Okay. And do we have the foster care worker available? I can't really, my eyesight is bad enough, I just can't read the screen from this far away.
He's there.
Okay.
His name is Michael.
Okay, before I end my questioning with you, Ms. Brown, is there anything about Ms. Clute that you feel the court should know that I did not ask you about?
No.
Mr. Brown, do you have questions for the witness?
Yes. Ms. Brown, you indicate that Ms. Clute was in the hospital 2 times to have a C-section and left after being there for a short period of time, correct?
Yes.
Did she leave against medical advice both times?
Yes.
Further, when talking about Ms. Clute's
Instead of chasing dramatic accusations, the attorney develops a foundation through mental health history, treatment compliance, prenatal decisions, and prior agency involvement. Each answer connects to the next, creating a structured theory instead of scattered complaints.
mental health situation, did you do any investigation into Jackson County probate records to see whether she has ever been hospitalized through Henry Ford Hospital or what was previously Allegiance Hospital and previously Foot Hospital? Did you do any investigation to see how many times she's been hospitalized for mental health issues?
No, I did not.
Judge, I would ask that the court take judicial notice of, I know the court probably does not have access to the probate section's files, but it's my understanding and belief that Ms. Clute has a lengthy history of both voluntary and involuntary long-term hospitalizations for mental illness. So I think that is another sound basis for her previous treatment or lack of treatment and following through with multiple hospitalizations over the last 10 years to take judicial notice of those.
The court will take judicial notice of the Jackson County probate files of the mother.
Thank you. Nothing further.
Thank you. Next witness.
Thank you, Your Honor. Again, I
May
apologize.
Ms. Brown be excused?
Yes, Your Honor, I would ask that she stay on the Zoom call for now, though.
Okay. Fair enough.
And I apologize, I just can't see the screen that well.
Michael Mangini, I believe, is the foster care worker.
Okay, thank you. Next witness would be Michael Mangini then.
And I muted. Let me unmute. I was in a lot of background noise from him. Let me do this.
Your Honor,
Yes, sir.
I was hearing everything, but I don't know why you can't hear me.
All right, we can hear you fine now. So,
Awesome.
all right. Would you raise your right hand, please?
Yes, Your Honor.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name, spell your last, please.
Michael Mangeni, M-A-N-G-E-N-I for Mangeni.
Thank you. Go ahead, Ms. Tucker.
Thank you. Mr. Mangini, you are employed with the Department of Health and Human Services?
I'm employed with Samaritas that represents the department.
Okay, I apologize for that. And so are you the foster care worker for the minor child Kingsley Clute?
Yes, I am.
Okay. Have you been the foster care worker on Kingsley Clute's case since the beginning?
I have been.
Okay. And what can you tell me about how Kingsley is currently doing at his foster care placement?
Kingsley is thriving. She's been able to get all her vaccinations. That was a struggle in the beginning, but thankfully we were able to work that out. And she's had her well child. She's enrolled to the early on program, and the foster care parents are doing a really awesome job at meeting her needs.
Thank you. Is it fair to say that Kingsley has been in the same placement since the start of this case?
Yes, she was taken from the hospital to the placement that she's at right now.
Okay. And that placement is not a relative of Ms. Clute, correct?
No, it's not.
Is it fair to say that you were familiar with why Kingsley came into care?
Yes, I am.
Based on that, do you feel that it's in Kingsley's best interest to have the parental rights of Ms. Clute terminated?
From my interactions with Mrs. Clute, yes, I would agree.
And can you tell me why it would be in Kingsley's best interest?
I've tried to ensure that she gets parenting time, and when I got Ms. Clute's phone number, I was able to reach out, and last week on Friday, the foster parents and I were able to drive out to Jackson at Cascade Park for parenting time. And it was initially supposed to happen for 1.5 hours, but Ms. Clute only attended an hour of that session and then left. And then she's just been non-committal. She will say something else and then backtrack on that. And at the last, whenever we met last Friday, she said she was not able to care for Amanda, and she said she's better off without her. But there has been like contact, video calls between Miss Clute and the foster parents to ensure that she gets that time, the interaction.
So if I'm understanding you correctly, it sounds like Ms. Clute has participated in some video calls, but when it comes to in-person parenting time, that's more hit or miss?
We've had one so far. We just had one to kind of try see how we could proceed going forward. But then
The legal strategy becomes much more deliberate once the questioning turns to the statutory grounds for termination. Rather than relying on emotional testimony, the attorney walks through each legal requirement one at a time, forcing every opinion to connect to a specific element the court must eventually rule on.
It was just a bit strange in comparison to the parenting times that I have supervised. Because she was saying the baby hates her because the baby was crying. Yet the caregiver had just changed Kingsley's diaper. So she's just back and forth, and non-committal.
Okay. Do you feel that Kingsley would have a sense of permanency or security with Ms. Clute if she were placed with her?
No, because whenever I go to talk to Miss Clute, first she was living with a friend of hers, and then she told me that she got kicked out and she's living with her cousin right now. And she's mentioned to me that she's been advised not to live alone, that she would need to live in an apartment that has someone else.
Okay, so in terms of housing, you would have concerns of Kingsley having a consistent place to live?
Yeah, right now I wouldn't count on that with Miss Clute.
What about, well, let me ask you this. What kinds of things would you like to see Ms. Clute do or complete if she were to ever get placement of Kingsley? Or before you would allow placement of Kingsley to be there? Yeah,
she would need to do random screens, undergo parenting classes, psychological evaluation, and go for therapy for substance abuse, obtain proper housing, and be able to maintain it. Yeah, those are some of the things that we'll be looking at.
How long do you think it would take for Ms. Clute to get in a position that she could have placement of Kingsley, given what you just listed?
It would take months, to be honest, because she's told me she's not willing to undergo some of these things, to do some of these services that I just listed.
She told you she's not willing to complete some of those?
Yeah, like psych evaluation and like parenting classes, saying she has not been given an opportunity to parent.
Thank you. Is it, would you be comfortable saying there is a bond between current placement and Kingsley?
Yes, there is a big bond. The caregivers I was just out there on Friday for a home visit, and you can see it. She loves to be held, and yeah, they're giving her the care that she needs and deserves.
Should termination be granted, do you have any indication of whether placement is interested in adopting Kingsley?
I haven't posed that question yet, but they the placement says they're willing to go to provide care to Kingsley as long as she needs it.
Is there anything else regarding Ms. Clute that you think the court should know that I did not ask you?
She feels that the system is biased, and that it's out to get her. So she just, anything that I would say, or anyone that works for DHHS would say, she doesn't believe it. She doesn't.
Thank you. Is there anything regarding Kingsley's best interest that you feel the court should know that I did not already ask?
No.
Okay. Thank you. I have nothing further.
Questions, Mr. Brown?
Yes, Mr. Mangini, is Kingsley placed here in Jackson County with his half siblings?
No. She's placed in Washington in Ann Arbor.
Okay. Is there some reason why Kingsley, wasn't explored? You're aware that Kingsley has half siblings that are placed in a adoptive home here in Jackson County, correct?
Yes, I saw that on the petition.
Okay. Is there some reason why that wasn't explored to try to keep the siblings together?
Since the case came through Wayne County, and they reached out to the agency, and we had caregivers willing in Ann Arbor, that was considered first, because we knew there were children in the that had been adopted, but we didn't know where they were placed. We didn't know if it was Jackson or what county, so it wasn't very clear.
That wouldn't have been very hard to find out, though, would it? Don't you feel as though if those...
The respondent begin working against her because they reinforce concerns about self-control during an already high-stakes proceeding. Cross-examination also exposes an important distinction between assumptions and first-hand knowledge, showing the court where evidence is direct and where it depends on records or prior history.
Parties would have taken placement or even known this was occurring, that in Kingsley's best interest, maybe he should have been placed with his siblings?
Usually, we have the licensing team that usually takes care of placement, and then once a child is placed, then the foster care department comes in.
You're not.
It was a bit hard because there was scanty information. Like when the case came in, we were trying to make sure that Kingsley gets the necessary medical attention that she needed, because no one had given consent and to her getting vaccinations and all these other things. So I think it must have got lost in between there.
Yeah. Are you the foster care worker?
Yes, I am.
Okay. Have you reviewed Miss Clute's history of mental illness, her hospitalizations, and any treatment that she's ever had?
The only document that I've been able to review is the petition, and I hadn't gotten anything else to that effect.
Do you know if Ms. Clute has ever completed any service? I mean, I say completed any service that was offered to her by either the Jackson County Family Court, DHHS, or Henry Ford Hospital, or any other mental health providers, whether she's ever completed anything? Do you know that?
I know she has not, and it's something that I talked to her about, and she said she hasn't done any of those services because she felt they weren't really helpful.
In the previous cases where her children were terminated or she released parental rights, correct?
Pardon?
We're talking about the previous cases where her parental rights were either terminated or she released her parental rights, correct? Or services. Yes. She's never completed one, correct?
Correct.
And this has been years in the progression, from 2015 to this date. She's never completed a service with regard to trying to maintain custody or get her children placed with her, correct?
Correct.
Mr. Mangini, I'm the lawyer guardian ad litem, and through my investigation, I have not been able to find out who the foster care agency is. When we go offline here, can I give you my email address so you can provide me with the placement information for the foster care parents?
Yes, please.
Thank you. Nothing further, Judge.
So, Mr. Magnani, can you tell me whether or not you observed any evidence of a bond between Ms. Clute and the child?
Yeah, when we had that visit, she was able, she kind of first stepped away and was crying and saying that the baby hates her because the baby was crying when she tried to hold her in the first attempt. But when the baby had come down and was with her bottle, she was able to hold her and said how cute she is. And she also brought with her new clothes that she had bought. So you could see that there was something. And she's also been having a 15-minute video call with a foster parent. But it's my understanding that that week on Wednesday and Thursday, last week on Wednesday and Thursday, she hadn't participated in those.
All right, well, I want to make sure we're clear here. You have testified that you have observed a strong bond between the foster parents and the child, correct?
Yes.
Did you see any bond of this child to Ms. Clute?
She was calm when she was being held, and Your Honor, to be honest, we've had one parenting visit, and we were not able to complete the set time or the set the target that we had at hand. So in one visit, it would be very, very hard to determine, since Kingsley is a baby and she's not very able to express how she feels, but in one visit, it will be very hard to kind of determine that.
Thank you.
You're
Any further questions for this witness?
No, Your
No.
Honor.
Any further presentation, Ms. Tucker?
No, Your Honor.
Any presentation, Mr. Brown?
No, Your Honor.
The second witness changes the focus from historical concerns to present-day reality. Instead of debating what happened months or years earlier, the testimony measures the child's current stability against the parent's current capacity.
I think we're ready for arguments.
Thank you, Your Honor. In terms of adjudication, obviously this is a permanent request filed that way right out of the gate, but looking just first at adjudication, we heard testimony regarding Ms. Klut's severe mental health issues, including a diagnosis of post-traumatic stress disorder. We heard testimony that this condition does require medication and that Ms. Klut is not in compliance with medication. It does also require counseling, which she is not in. And it seems that this mental health issue seems to present itself in many ways, including not even being able to communicate with any of the workers enough to even get this case really started. We also heard about Ms. Klut's issue with homelessness. She was homeless, and she, despite telling the workers otherwise, the workers have never been able to verify or visit or see any sort of residency from Ms. Klut. We heard about prior terminations of her children here in Jackson County. It sounds as though it got to the point where the agency was requesting termination and then Ms. Klut relinquished her rights. And then we also heard more specifically to Kingsley about Ms. Klut's issue with controlled substances, to the point where she did not receive proper prenatal care. She went to the hospital twice for scheduled C-sections and left without those procedures being completed and against medical advice. And unfortunately, Kingsley was born positive for controlled substances herself. So in terms of adjudication, I think there's a wealth of reasons for the court to take jurisdiction of this child at this time. Because this is a permanent request, we do also have to discuss termination. I deliberately went through each of the bases for termination with the worker, just to give the court as much information as we could. The statutory basis in terms of deserting the child for 28 days, we heard the worker say that's more directed towards the dad. So then looking at the other bases, it's clear from the testimony that Ms. Klut is not able to provide proper care and custody for this child in terms of simple things like not having a bassinet or any of the supplies necessary to care for the child. But then also going back to her mental health issues, not even being able to communicate well with the workers or anyone that tries to step in on behalf of this child. That's extremely concerning, given some of the issues that Ms. Klut could be assisted with. She just refuses to do so. We've talked about the prior terminations, and the court has taken judicial notice of that file, so I won't spend a lot of time on that. But then we have whether or not Kingsley would be harmed if returned to the care of the parent. There's a lot of testimony regarding Ms. Klut's kind of lack of participation, or if she does participate, her really hostile nature towards everyone, to the point where she's told the foster care worker that she's not going to do certain things like psych eval or any number of services, and she refuses to do so, or she cannot do so. And what I mean by that is, again, she cannot even communicate well enough to begin some of those services. We heard the foster care worker say that Kingsley is doing very well in foster care, that she is very well bonded to her foster care parents, and that they provide a sense of permanency and stability to her. Ms. Klut is not able to provide that permanency and stability for any number of the reasons I just listed. And she seems very resistant to any sort of help. Kingsley is again doing well. I don't think this is a situation where if we give mom time to participate that she's going to turn this around. I think this is a situation where it's in the best interest of Kingsley to terminate the parental rights today as opposed to drag this case out, hoping that mom will get her act together when she has shown time and time again that she is not willing or not able to do so. So with that in mind, I would ask that the court take jurisdiction of the child and terminate parental rights. Thank you.
Thank you. Mr. Brown?
Just real briefly, Judge, I have been doing this for over 25 years, and I've been the lawyer guardian ad litem throughout these proceedings for years with her other children, and I don't think I've ever observed a respondent parent who was more detrimental to a child because of the lack of mental health care than Ms. Clute. Not all people with mental illness are dangerous, but I think she's violent. She's a violent mental health patient who presents an extreme danger, not only to Kingsley, but probably to many people that she's around. The probate file will list numerous mental health hospitalizations, which she never completes. She's been in our system with the abuse and neglect arena with numerous children, and she's never completed a service. And nothing's been presented here today that shows that she's rectified those situations that brought the other two children into care on her own. So for those reasons, I think it's in Kingsley's best interest, along with the statutory basis. I think Ms. Tucker has approved a statutory basis and shown that it's in the best interest of Kingsley, not only in his best interest, but for his safety and well-being to not be in Ms. Clute's care. I would be very, very concerned with any child being in her care. Thank you.
Cross-examination introduces one of the few areas that could potentially challenge the agency's position by questioning placement decisions and the possibility of keeping siblings together. That line of questioning is strategically important because it tests whether the department explored every reasonable alternative before seeking permanent termination.
Thank you. The court has listened carefully to the testimony and obviously has had a long history with Ms. Clute, consistent with her behavior in every prior petition. As we talk about adjudication, she simply is either unable or unwilling to provide proper or necessary care for a child, for any child, and certainly not for Kingsley. Based on her admission, she didn't even have a home in which to care for Kingsley. She did not have the basic necessities to care for a child. In addition, she failed to seek prenatal care, and both she and the child were drug positive at the child's birth. So not only is she unable to provide proper care and custody, she was also had a home environment, or I should say an environment. It's hard to talk about a home environment for someone who doesn't have a home, but certainly whatever environment the mom is living in is one that, by reason of her drug abuse, makes it an unfit home. And I want to be very clear about the mental health issues. The court would never adjudicate or terminate the rights of a parent just because they have mental health issues. The concern is the behaviors that result from her mental health, and in particular, her inability or unwillingness to get proper treatment for those mental health issues. The result is, as was evidenced on the record today, I gave her many opportunities to participate. She could not keep quiet. She was explosive, combative, and that's consistent with the testimony that the court heard from the workers who attempted to deal with her, and in fact, with anyone who's attempted to deal with her in the prior cases that this court has presided over. So clearly, a basis for adjudication exists. The same basis, frankly, although the statutory grounds language is different, also provide ample ability based on clear and convincing evidence that grounds for termination have been met. The mother has had at least 3 prior cases that on the eve of a termination hearing, she chose to release her parental rights rather than go through a termination hearing. But the court remembers well, there's been no change. There's been no improvement. Ms. Clute behaves the same today as she's done throughout the course of this case. There's been serious and chronic neglect and a failure to rectify the conditions that led to the prior terminations, even though they ended up in releases, they would have been terminations because she's routinely refused to engage in a treatment plan. She's refused the services that have been offered to her and clearly continues to suffer from the behaviors that are a direct result of not having her mental health condition addressed. There is not merely a reasonable likelihood, but there is an absolute certainty based on the conduct or capacity of Ms. Clute that this child would be harmed if returned to the home of this parent. So clearly, based on clear and convincing evidence, statutory bases exist to terminate her parental rights. And I believe, without question, termination of parental rights is in the child's best interest. This child deserves permanency, stability, and finality. That is.
The judge's questions about bonding also expose another legal distinction that often gets misunderstood. A brief positive interaction is not automatically evidence of a secure parent-child relationship, especially with an infant whose attachments are still developing.
Not likely ever to be achieved with this mother, no matter how much time she's given, but certainly far more time than this court would be willing to allow for any attempt at reunification. The child is well bonded with the foster parents. She is in a home where, in a home. With the mother, there isn't even a home. So it's hard to compare the two homes when there's only one home that is a suitable home for this child. The history of ongoing behaviors by the mother make it very clear that it is in the best interest of this child to be permanently protected from ever having to return to that environment. I tried to elicit testimony about the bond. It's clear to this court it's impossible for this child to be bonded to a parent that she's had so little contact with. There's no doubt in this court's mind that even though the child was able to be calmed, to briefly sit in the mother's lap, that is not evidence of a bond. That's just evidence of a well-behaved child, which also is a strong indication of the nurture that this child is receiving in the foster parent's home. So for these reasons, the court finds that termination is in the child's best interest. We'll set this matter for a post-termination hearing.
October 27th at 9 a.m.
Was everybody able to hear that?
Yeah.
And so where do I send mom's advice of rights, order terminating parental rights? Do we have any address that we can send things to?
The petition has an address on it. Looks like it was handwritten in. Ms. Brown or Mr. Mangini, do you know if that address is still
We're not getting mail returned to that address, so I can only assume she must be picking it up or getting it. I don't know what the address is, so that's where we will send the paperwork concerning the court's decisions today. So unless there's something further, I think that concludes our hearing.
I need to give Mr. Mangini my email address so he can provide me placement information.
Mr. Brown.
Mr. Brown?
Yes.
We're the foster parents. We're here. I'm sending you an email right now with our information.
How would you know my email address?
Well, I was going to send it to what was listed on your website, but if that's incorrect, I apologize.
That's my office email. And
Okay.
I'll get it, and I normally wouldn't.
Okay.
You go off YouTube, so
Sure.
I could that to them.
All right, let me take us off.
Closing arguments reveal how each side wants the judge to interpret the same record through completely different lenses. The petitioner's strategy is not to overwhelm the court with emotion, but to present a consistent pattern showing why additional time would likely produce the same result as previous cases. Every major concern is tied back to practical parenting. Untreated conditions, unstable housing, missed opportunities, and repeated refusals to engage with services. The guardian ad litem reinforces that argument by emphasizing years of first-hand involvement instead of focusing only on the current petition. That perspective adds historical context without replacing the evidence already introduced. Together, the attorneys shift the discussion away from hope and toward probability. The central question becomes whether the court should invest more time waiting for change or act on the repeated pattern already established throughout multiple child welfare proceedings. The judge's ruling demonstrates the difference between recognizing a medical condition and evaluating the behavior that flows from it. The court carefully separates mental health itself from the legal standard, making clear that the decision is based on conduct, treatment refusal, and parenting capacity rather than a diagnosis alone. That distinction strengthens the ruling because it addresses actions supported by testimony instead of assumptions. The judge also weighs the mother's history against the child's immediate need for permanence, concluding that repeated opportunities have not produced meaningful progress. Even the discussion about bonding reflects this practical approach. A calm interaction during a single visit cannot outweigh months of consistent caregiving elsewhere. The final order prioritizes stability over uncertainty, signaling that family court ultimately measures decisions by the child's future, not the parent's intentions.